Before I get started, I want to introduce Lauren Howe, who's a compliance attorney with us here at MMIS. Lauren joined us a couple of months ago from a large medical device manufacturer where she was responsible for helping with the establishment of policies related to their open payments reporting and implementing their solution, their overall solution. And Lauren has been spending much of her time on the international transparency requirements and regulations. So to the extent that you have any questions in the future on those requirements, please feel free to reach out to us, and I will put you in contact with Lauren. So the agenda for today's meeting, we're going to look at some of the drivers for global compliance processes. We're going to talk about different approaches for managing HCP engagements throughout your enterprise, so looking at it from a global perspective. And then we're going to look at some risk assessment and auditing and monitoring tools that'll hopefully help you not only with the U.S. transparency, but also global transparency and compliance as well. In terms of why this is getting so much attention as of late, if you look at the forecasted global growth for the pharmaceutical market, you'll see in the largest orange box in the growth markets, that is where the most growth is expected through 2020. If you look at the growth markets that are included in there, the largest ones are China, Brazil, Russia, and India. So what we're anticipating is that you're going to see more and more anti-corruption enforcement in those particular markets. A good example is what we saw a couple of weeks ago with the conviction of GlaxoSmithKline in China for anti-corruption violations there. In terms of some recent developments, last week Sanofi just disclosed an internal corruption investigation, and that was brought about as a result of a whistleblower. And I think what you're going to see in the future is more and more whistleblowers around the anti-corruption area, and that's primarily due to the fact that the Dodd-Frank Act, which was enacted in 2010, added a specific whistleblower provision for those individuals that provide original information to enforcement authorities, which leads to a monetary sanction or a penalty that's greater than $1 million. If that's the case, then the whistleblower can receive up to 10 to 30% of the funds that are collected by the government. So similar to the some of the anti-kickback related litigation in the United States over the last 10 years or so, I think you're going to see more and more whistleblowers in the FCPA area. Also, as I mentioned, China just recently fined GlaxoSmithKline. I think it was around 490 or so million in the recent bribery case. Although that settles the issues in China, it's likely that the Department of Justice will open a FCPA investigation with regard to those allegations as well. So it's probably not over for GlaxoSmithKline. So some of the other drivers for global HCP compliance strategies, I think the spread of global transparency legislation in general is indicative of increasing scrutiny around the globe on pharmaceutical and medical device manufacturer payments to HCPs. We've also seen the passage of additional anti-bribery laws, which we'll see in a minute in Brazil. So that's starting to spread as well. And if we look at the SEC FCPA enforcement over the last couple of years, 50% in 2012 were against pharmaceutical or medical device companies, and then 25% in 2013. The HCP transparency, I think, is definitely here to stay. These are the jurisdictions where there's currently a requirement for reporting or there's pending legislation. So you'll see, in addition to the United States and France, which most companies are familiar and preparing for, we also have Slovakia, Portugal, the Netherlands, Romania, Denmark. Australia is pending some additional legislation, and Colombia just announced legislation about 2 weeks ago that would require reporting in 2016. And then starting in 2015, FPA is requiring data collection for reporting in 2016 for the 32 FPA countries in the EU. In addition to the transparency laws, when we're talking about interactions with HCPs on a global basis, you also have to consider the laws and government regulations. So on an international basis, things like the FCPA Act, the Anti-Kickback Statute, the OECD anti-bribery provisions, Sarbanes-Oxley. You have the EU directive, and then the national laws, which are specific to each country in the EU. You'll obviously have your own company policies and procedures designed to address those laws. And then there's also the various codes and self-regulating bodies. So the International Federation of Pharmaceutical Manufacturers, FPA, EucoMed, for example. And oftentimes those codes may contradict or not line up exactly with the various laws and regulations. So your policies and procedures should be designed to address the various requirements as they specifically relate to HCP interactions. Some of the anti-corruption laws, the big one obviously that here in the United States is the FCPA. There's also the UK Anti-Bribery Act. As I mentioned, Brazil just passed legislation earlier this year to address a lot of corruption which was happening as a result of them hosting both the World Cup and the Summer Olympics coming up. So Brazil is another jurisdiction with significant anti-corruption legislation. In terms of the FCPA, U.S. officials and European regulators have been working very aggressively and closely in investigating foreign bribery cases. Part of the reason that the pharmaceutical and medical device industries are a target of the Department of Justice and the SEC is because just the nature of the industry provides that manufacturers are always in close contact with government authorities. Particularly in Europe, most doctors and hospital administrators will meet the definition of a government employee, which brings into question any type of value transfer that you make to those individuals could implicate the FCPA. So it's important to understand who you're providing transfers of value to in Europe and what the ramifications are. Just briefly, the FCPA has two parts, the anti-bribery provision and also the accounting provision. And those two provisions don't necessarily go hand in hand. So for example, in the Diebold case last year, the Department of Justice found some violations of the anti-bribery provisions, I believe it was in China, but they also found unrelated accounting violations in Russia, which didn't involve a government employee, rather it involved a third party, a private company. So you can be found in violation of the accounting provisions without actually any bribery taking place. And essentially the accounting provisions require you to maintain books and records and internal controls that are sufficient to allow the organization to comply with GAAP accounting practices. It's important to note that the accounting provisions only applies to issuers, so those would be publicly traded companies on an exchange here in the United States. The enforcement of the FCPA is the Department of Justice has criminal and civil responsibility, and the SEC has civil jurisdiction only. The Act applies to U.S. issuers, as I mentioned, domestic concerns, so those are any companies that are doing business within the United States, and then as well, any person or entity that engages in any act in furtherance of a corrupt payment while in the territory of the United States. So it's pretty broad and all-encompassing. In general, it prohibits an individual or an organization from corruptly making, offering, or promising to make a payment, gift, or anything of value directly or indirectly to a foreign official for the purpose of obtaining or retaining business. And then, as I mentioned, the accounting provisions require you to maintain sufficient books and records and internal controls. There are a couple of exemptions under the FCPA. One is for facilitation payments. So those would be routine payments for routine governmental action, which would be defined as something that was ordinarily and commonly performed in the particular jurisdiction. So in some countries, for example, that may involve making a small payment to a customs official to process the customs form. There are also affirmative defenses. The big one is that applies to often applies to pharmaceutical and medical device companies, would be reasonable and bona fide expenditures, including travel for the promotion or demonstration intended to promote or sell a product. So you can provide reasonable and bona fide expenses, things like travel, food and beverage, to a government official, including a doctor, for example, in a country in Europe with a state-run medical system, provided it's considered reasonable and it is bona fide. Some of the common SEC and enforcement priorities that they've announced in 2014, one is they're focusing on individuals as well as organizations. So over the last several years, they've brought around 190 actions against individuals for violations of the FCPA. There's global cooperation and enforcement, which you saw in China with the GSK case. Unfortunately, when you're talking about global cooperation, a lot of the countries don't have the due process that we have here in the United States. So, for example, in China, you saw the Chinese officials actually show up at GSK, arrest and jail, I think it was about 15 executives without any due process. So there is cooperation, but it's not necessarily consistent with our standards here in the United States. More and more, the DOJ and SEC are using corporate monitors if they do find violations. They're encouraging self-reporting and cooperation, and that obviously helps in lowering any penalties or fines. There's greater emphasis on the importance of corporate compliance programs. The DOJ has indicated that they're going to try and speed up investigations, which will obviously help organizations save on expenses. And then the SEC indicated that they will be relying more and more on those whistleblower rewards under Dodd-Frank that I mentioned earlier. There are currently 150 active cases in progress with the Department of Justice. Over the last year, we've seen 3 of the top 10 largest fines, which you see on the screen, and more there are larger investigations. Walmart's a good example, where they recently disclosed that they've spent about $439 million in legal fees and expenses alone, just in conducting their ongoing FCP investigation. And the most common types of FCPA cases in 2013 were traditional bribery, as well as improper travel and entertainment expenses, and also another common one that we're starting to see are enforcement with regard to charitable donations. A good example of the travel and entertainment issues occurred in the Stryker case. So in that particular case, what happened was, in exchange for the promise of future business from the director of a public hospital, Stryker paid some travel costs for the director and her husband in 2004, which included a 6-night stay in New York City and attendance at 2 Broadway shows, as well as a 5-day trip to Aruba. So those are some examples of violations relating to the travel and entertainment. And there was also, in the Stryker case, a donation that was made for about $200,000 in 2007 to a public university in Greece. And the genesis of that donation was to fund a laboratory, which was a project, a pet project of a public hospital doctor. So that was also seen as a violation of the FCPA because the doctor had agreed in exchange for that charitable donation to provide additional business to Stryker. So charitable donations are another area to look for. The biggest risk areas, as identified by both Department of Justice and the SEC, are third-party intermediaries. So since 2012, 70% of all the SEC cases involved some type of third-party intermediary, whether it was a vendor, a supplier, or a joint venture partner. Kara Brockmeyer, who is the chief of FCPA enforcement for the SEC, has indicated that she's continuously amazed, and more and more companies are doing business with third parties without any formal process for vetting those third-party intermediaries. So it's not only important to have a policy to vet all third parties, but to thoroughly document that process as well. Some additional international anti-corruption laws to be mindful of. The UK Anti-Bribery Act has been described as the FCPA on steroids. It not only covers public bribery, consistent with the FCPA, but it also covers private bribery. And it covers any entity or person that does business in the UK, regardless of where the acts took place. There's also the OECD Convention on Combating Bribery. And then, as I mentioned, Brazil just recently adopted the Clean Companies Act in 2014. Interestingly, with Brazil, they specifically have provisions in their legislation that defines what a foreign public entity is and what a foreign public official is. And they specifically state that it includes individuals with temporary or unpaid employment at a public entity. So because Brazil has a state-run medical system, any employee, whether they're temporary or even unpaid, of that hospital, for example, would be considered a foreign official. The other law that we're mindful of in the United States is the anti-kickback statute, which provides for a criminal prohibition against payments made to induce or reward the referral or generation of federal healthcare business. So any payment or transfer of value that you make to an HCP here in the United States has implications under the anti-kickback statute, which we're familiar with. In 2003, the OIG created a framework for managing HCP engagements, and that was under their guidance for pharmaceutical manufacturers, which is also instructive, I think, for medical device manufacturers to be mindful of and to follow. And they specifically identified different risk areas under the anti-kickback statute. A big one, obviously, is relationships with physicians and other persons or entities that are in a position to make referrals. And as I mentioned, the guidance document establishes a good framework for dealing with and managing HCP engagements, which requires an agreement in writing signed by the parties. It needs to document all of the services to be provided by the HCP. The term of the agreement has to last at least for 1 year, and importantly, the aggregate compensation paid over the term has to be consistent with the fair market value in an arm's length transaction. So that's really the anti-kickback statute is really the genesis of the fair market value requirements for healthcare providers. So with all this in mind, in terms of managing HCP engagements, what companies are starting to do because of the spread of transparency, so obviously we're all aware that when the CMS site is up and running, you can log on and you can see the payments that companies have made and reported. But we're also, you can log on in France now and see those payments made to French healthcare providers. And as the different countries around the EU bring on their reporting requirements over the next year or so, you're going to be able to have visibility into all of the payments around the globe as they relate to healthcare providers. So companies are really starting to look at a couple of things. One, is there, and what is the strategy for the approach to global transparency? Is it going to be handled at a local level for each country to deal with, or is it going to be handled with a global approach? The other thing that transparency is exposing more and more are cross-border transactions. So, for example, if you have a meeting here in the United States, you not only have a U.S. healthcare providers, but you may also have French healthcare providers or Danish healthcare providers. What are the requirements in France for those relationships, not only of reporting, but also for the agreement, for example, with a French healthcare provider? Are you following the rules for submitting those agreements to the ministry for approval in a timely manner? So all of the transparency is exposing the need for well-defined processes for managing global HCP compliance and global transparency reporting. So companies not only are starting to consider whether there is a global approach, how the data is being collected, what type of systems are tracking the payments on a global level, but is there an opportunity to manage the anti-corruption piece and the overall HCP engagement on a global level? So the slide here in front of you is really the process through which companies are starting to look at HCP engagement. So establishing and documenting the purpose for the engagement. So what type of interaction is it? Is it consulting, speaking, research? Being able to document a legitimate purpose for the engagement and establish the objectives for the engagements. Being able to establish the qualifications for the participants. So, for example, are national key opinion leaders required for the engagement? Is it something that can be addressed through what you may consider a regional key opinion leader? So really establishing the qualifications for the particular event, defining the location for the event, and also defining and signing off on the budget for the event, the overall budget as it relates to the event, but also as it relates to HCPs. So the number of attendees, the level of expertise that's required for a consultant or a speaker, for example, their employment status. You know, are they employed by an organization that would be considered a governmental organization? So a hospital in a state-run hospital system in Europe, for example, that may implicate some of the anti-corruption and anti-bribery requirements. And then what's the fair market value? Obviously, the fair market value may differ for a physician here in the United States versus a cardiologist in Hungary or one of the other or a country in South America, for example. So really understanding the fair market value in the different jurisdictions for which you're engaging healthcare providers. And then the contracting process, being able to manage standard contracts and standard clauses. Being able to manage, for example, consents for disclosure in the EU, which is very different than here in the United States, where there isn't as much attention on the privacy issues. Then once the engagement is underway, being able to check the contract status, being able to track that everyone has a signed agreement, being able to monitor the event to make sure that it's consistent with the objectives and the purposes that were established and proved, having a participant list and a sign-in to be able to document attendance, and then being able to, following the event, being able to document that the services for which the HCP was contracted was delivered, being able to document an invoice from the HCP, the approval process for payment, the report of the payment if required. So for example, if the physician's from Italy, that payment has to be reported to their employer, and then the disclosure of the transfers of value consistent with the different country requirements. So in that cross-border example, being able to make sure that all of the disclosures for the French and the Danish physicians are being made to the relevant authorities in those particular countries. So really putting together a process and the policies to manage the HCP engagements on a global basis to address the various issues that are outlined here. What we've been doing as an organization over the last year and a half or so is working with a partner to look at some of the common elements of this entire process based on companies that are either undergoing some type of anti-corruption investigation or have gone through the process and have a deferred prosecution agreement or an NPA with the Department of Justice. What we've done is we've looked at the different requirements that have been imposed by the DOJ and put together a workflow and some standards that are designed to meet the requirements that the Department of Justice is looking for as it relates to the policies and the procedures that I just mentioned. So conducting the needs assessment, being able to establish and document the fair market value process, being able to have a qualified pool of HCPs that are validated from within the organization. So you don't have individuals from a marketing department, for example, or sales picking HCPs as consultants, which may implicate issues around the anti-kickback statute or the FCPA. So being able to document this entire process from identification of a legitimate need all the way through the spend tracking and reporting process, which is, as we've been talking to companies both on the pharmaceutical and the medical device manufacturer side over the last year or so, this is what companies are starting to look into as global transparency is becoming more and more on the forefront. So some of the workflows that companies are working through: charitable donations, as I mentioned in the Stryker case, consultant and speaker arrangements are common, research and grant funding for individual HCPs or practices, third-party educational conference support, travel support for healthcare professionals, which is common over in Europe, and then things like fellowship and grant support, and then the provision of educational items and gifts. So the idea is that through a central tool, you're able to document the entire process and clear transactions and arrangements through a central compliance department. What it does is it allows you to take into consideration specific country requirements and or limitations. So for example, limitations in Turkey in terms of the number of times you can use a particular healthcare provider. If you're not tracking that in some type of central location, then you're never going to have any idea from a global basis whether you're violating any of those requirements. It's also designed to give you the ability to route transactions to the appropriate local representatives for approval. So a good example is a device manufacturer who uses a central process that was designed in-house, where if anybody within the organization wants to use a French HCP They have to log into the system. They have to document the need for the French HCP, and then that automatically gets routed to the appropriate compliance manager on the local level in France to make sure that they're working with the individual, for example, in the United States, to make sure that all of the requirements in France for engaging an HCP are taken care of. It also gives you the ability to manage a master database of global HCPs, so not only leveraging US, but also leveraging ex-US data providers, which is a little different in Europe, but there are a couple of data providers that manage data from all of the different countries within the EU, and then also having the ability to tie in those fair market value rates and calculations. A comprehensive system like that also gives you the ability to do some automated auditing and monitoring. What we would encourage is that you collect as much data as possible when you are looking into complying with, for example, the global transparency requirements. Collect as many data fields as you can that may provide assistance in the auditing and monitoring process down the road. So what we've done is we've taken an internal tool and we've looked at some of the data that was presented on the CMS Open Payments site. So you'll see here on this screen what we're looking at are cash or cash equivalent payments for food and beverage. And down in the lower left, you'll see we have the top 100 physicians. So there's one particular physician who, for the 5-month reporting period, received close to $79,000 in food and beverage payments, which is hard to imagine. When you drill down, you see that 78,000 of those payments were from one particular manufacturer. And then if you drill down further, you'll see that a single transaction was for $68,750. So it's very likely that that particular transaction was a mistake, which wasn't caught by the manufacturer during the review process. Unfortunately, because of CMS's rules, that transaction is going to be in the public domain until the data is refreshed next June. So obviously, the doctor to which this relates probably isn't particularly enthusiastic about being the top physician for receiving food and beverage, although it may be an error. Another example here is this is compensation for services rendered. So you'll see this particular physician was the #1 recipient. So this is compensation for services other than consulting. So it was about $734,000 over that particular period. So I think it's important, as this information becomes available in the public domain, certainly that internally you make sure that you have a process where all of the data is vetted before it's submitted. And the Department of Justice has indicated that they will use this data as really the first line in terms of investigating companies for potential violations of the anti-kickback statute or the FCPA. Another example, this is just royalty payments, which is interesting. It's about, the top physician was about $7 million in royalties over that 5-month period. And then the last one is similar to the food and beverage. It's for travel and lodging expenses. So you'll see the top physician received about $160,000. Similar to the food and beverage example, once you drill down into the actual transactions, it looks like it was probably a mistake and a miscategorized payment once again. But for this physician, it'll remain in the public domain at least until June. So some of the benefits of a global compliance process. One, risk mitigation gives you the ability to establish specific timelines for planning events. So in the example I gave with a manufacturer and their process for using French HCPs, they've got a defined timeline where you need to submit the request at least 2 weeks in advance to give appropriate time for planning and vetting the event. It gives visibility into all approved payments and transfers of value, visibility into the budget and the approval process for the budget, a centralized location for templates. It facilitates compliance with local country rules, so does give you the ability to engage local compliance professionals when healthcare providers are being used from their jurisdiction. You can manage transparency and data privacy issues. As we'll see with FPIA coming online in 2015 and 2016, there are specific data privacy and consent requirements in different countries within Europe. So you'll be required to actually get the consent of a physician to be able to disclose their payments and transfers of value consistent with the mandated reporting. So companies are now trying to figure out what their policies and procedures are. If a physician, for example, doesn't provide their consent, will they continue to work with that physician? Or if they do provide their consent, participate in the engagement, they then have the ability to withdraw their consent before you submit those payments to the relevant authorities under the transparency requirements. In those cases, companies are considering how they'll handle that. So will they aggregate those payments and report them in an aggregate amount and not disclose the name of the healthcare provider? So those are all policies that you'll have to wrestle with over the next 12 months or so. And it also provides a closed loop process to document any legitimate business purposes, the budget, the delivery delivery by the healthcare provider in terms of what they were contracted for, as well as documenting the payment. So it provides the closed loop for making sure that you're not violating the anti-corruption statutes that we looked at. So that's really it for the presentation today. Just one question, will you send the slide deck? Yes, we'll provide the slide deck to all of the attendees. If there are no additional questions, that's it. And I just want to thank you for your time. It's greatly appreciated, and feel free to reach out if you do have any questions that come up down the road. So thank you all for your time, and take care.